LFJ podcast. I'm your host, John Freund. With us today is Jonathan Stroud, General Counsel at Unified Patents. Hi, Jonathan. How are you doing today?
Good. How are you?
Excellent. Thanks for joining us. I think I'm just going to kick it over to you first and just have you introduce yourself, give us your background, how you're connected to legal funding. That'd be great.
Sure. My name is Jonathan Stroud. I am a General Counsel of Unified Patents, which is a membership organization. We'll get into that in a second. But I come by way of my backgrounds in biomedical engineering. I was a journalist. I went to grad school for journalism and was a journalist for a while and led many lives as a bartender and sold condos and did sales and some other things, and then landed at the USPTO, went to night law school, went to a law firm. And then after I was at the firm working on some patent litigation cases, I came over to Unified Patents about a decade ago. Unified Patents is a membership organization with about 300 members that is a defensive organization that files challenges to U.S. patents and foreign patents that it believes are invalid. Its membership is broad based across industry. And so we sit across a lot of areas and see a lot of things. And litigation finance really started to become important about 8 years ago. And more cases in the patent space have been funded. And it's had major implications on policy and strategy. We also do a fair amount of work on the Hill and in policy areas. And this is an area that's very important. And just through education and cases and counseling and advising and consulting, came to understand, and writing as well, came to understand a lot about the field. It's a very poorly understood field. And I'm certainly not immune to sort of misunderstandings about it, but I think we're at the cusp of, if not cultural relevancy, then at least sort of a widespread understanding of litigation funding and a lot of people getting concerned. And so I've become kind of a speaker and advocate on it, and I've been talking about it a fair bit with a lot of different industry players, particularly in the patent space, but also just in general.
Yeah, well, I actually kind of want to ask about all your previous lives, your bartending life, your selling condos. I feel like there's room.
I was a comedian for a while too.
Okay, all right.
Not a successful one, but so funny.
I did some improv and stand-up comedy back in the day, so this better be entertaining then.
Yeah, it won't be. Yeah, no. Now I'm old and boring, but those were different lives. But
those days are over. Yeah.
Yeah.
Well, okay. Well, we are talking about patents and IP, so that's the subject of today's discussion. And let's kick it off with the Litigation Funding Transparency Act. So that's in the news a lot lately. Maybe you can tell us a bit about that, how that act impacts your sector, IP, and what legal counsel and what funders should know, what they should be aware of.
Sure. So, I mean, the story of litigation funding is not one of no regulation. It's one of funding happening in a vacuum, because for the longest time, funding was completely verboten in common law jurisdictions. There were some exceptions to that, but it took a long time for the world to kind of come around, even to contingency counsel, and then to come around to the idea of litigation funding. And it's still a work in progress in a lot of different jurisdictions. There's still some jurisdictions that don't even allow contingency counsel or put strict caps on it. But as litigation internationally has grown more and more expensive and international, there's been a market need, obviously, for some type of alternative funding mechanism other than just borrowing and sort of floating for years. And so litigation funding has kind of come out of the woodworks over the last 40 years. There's been some around the edges in terms of something similar to sort of a payday loan, sort of borrowing against claims that happens a lot in civil courts in Australia and here as well. True commercial funding is only about 15 or 20 years old on a large scale, civil funding. And that funding market has exploded overnight, right, as an alternative investment. I think as private markets and hedge funds started to try to diversify their holdings, and as the private markets became a little bit saturated with companies that were buying and selling other companies, I think you saw a lot of players looking for an additional place or an additional alternative investment to park some of their funds. And so what you see now is a very keen interest. And that was an interest that was first sort of in the class action space, but it has definitely bled now into patents and antitrust and a whole bunch of other areas. And patents is sort of the biggest growth driver of that, with damages being as high as they are and with it being arm's length. So we're seeing a big kind of wholesale change in the litigation landscape. A lot of cases are funded by third parties. A lot of misinformation is being thrown around about who controls what and what's happening. And so it's a really interesting time to be practicing and commenting in this space.
Yeah, and you do comment a lot. You put a lot of content out on your LinkedIn. I recommend people go to your LinkedIn and follow you there. One of the recent posts you put out, you mentioned a lot of broad agreement on the need for disclosure. So I'm just curious because, yeah, there's a lot of broad agreement within the industry. There's also some points of disagreement. So where do you see the areas of consensus, and where do you see like the people disagreeing within the industry and when it comes to disclosure?
Sure. So two things. So when you're on the Hill and people, there's something that's wildly popular and yet it can't get passed, it's always important to remember that when the status quo is and doing nothing is fine for people and okay for now, a lot of people will prefer the status quo. And it's always harder to change something for the better or for worse than it is to do something. So on the Hill, you always bet against a bill. You always bet against something changing. And litigation funding is something that sort of happened in an area where there was no regulation, no disclosure, no real framework. And so people were sort of at risk doing it here and there. It attracts a lot of people that are very comfortable with risk. But the flip side of that is there's a big resistance within the industry to any kind of standardization or commoditization or treatment of the industry as a whole. And I think that's true for almost any new type of investment, right? There's a skepticism of people like me who are critics. There's a skepticism of regulators, right? And it makes sense. I understand it. But the risk of not engaging, there's a lobbyist will say, either at the table or on the table, right? The risk of not engaging on this stuff is high, in part because it would only take one case that went the wrong way for the entire industry to sort of feel the effects and crater. In private equity, they call it stroke of the pen risk, but you can look to the UK, or in the UK, litigation funding market was booming. There were class action, collective actions that were funded. And then this Packard decision came down from the Supreme Court. And the Packard decision, in the absence of regulation about litigation funding, put severe caps on litigation based on an interpretation of the court there. And it really damaged the entire industry there, to the point where I just heard that Ethereum Capital is basically being taken over by Fortress. It's basically, they've restructured, they've fired a bunch of people, and now they're taking their assets and sort of giving them to Fortress to manage. So clearly, the industry players that are successful right now within the United States are still engaged in the very risky practice of an area that is not yet regulated, but that easily could be through stroke of the pen risk. And so there's been a resistance from people that are funders in particular to sort of engage on these issues. And I think that some of the areas where people have asked for a little bit of disclosure or what have you, the standard line from funders is sort of like to be very skeptical of everything, to say there should be no change, there should be no engagement, there should be no discussion. If there is a change or there is a discussion, it must be in camera only, and to be very highly skeptical of anything. And I would counter that by saying, like, be careful what you wish for. If you end up slowing down or killing any type of disclosure, reasonable disclosure or reasonable type of regulation that would sort of pull this into the sunlight and allow the industry to sort of understand where it is and get its bearings, and allow the government to get their hands around it too, you run the risk of very serious unintended consequences of some decision or some downstream consequence that is sort of a stroke of the pen risk that you can't predict. So another example of this is Senator Tillis just released a bill that would basically tax litigation funding proceeds like regular income, which would right now they're not taxed that way at all, right? They're taxed sort of similar to a capital gains, but it's very different. This would, the Wall Street Journal did an editorial on it and supported it, and there's some discussion about putting it into a different bill. Whether that goes anywhere or not, that's just one example of regulation that would maybe go in a direction that the industry didn't want, or just on a different level. And there's also state regulations that are relatively draconian comparatively. So there's regulations being addressed in New York, California, Texas, a whole bunch of jurisdictions. I think there's been like 19 or 20 states that have already passed some form of regulation, and they're all over the map. So it's kind of a patchwork. So instead of advocates and members of the litigation funding community kind of coming together, which I think is against their nature too, and kind of engaging and supporting common sense transparency regulations, there's instead been this sort of obstreperous, like, we don't need to do it. We've never had to do it. We don't have to engage. And I think the very serious risk is that there's, in the interim, some other jurisdiction or some other decision maker makes a decision that reverberates through the entire industry and really hurts it, like it did in the UK. And it's hard to unring that bell. They're now demanding regulation in the UK, and they've been seeking it for the last 3 or 4 years since PACCAR, in vain, right? Because again, it's much harder to save the litigation funding industry through regulation than it is to sort of, formalize it and recognize it and then allow it to flourish, right?
Yeah, all of that makes sense. But the question then becomes like, what is reasonable? Would be reasonable regulation? So the Litigation Funding Transparency Act, for example,
Right.
is mandating disclosure of the funder's identity and the funding agreement. Is that reasonable? Would that stave off future regulation about, say, like cost caps or things? Or is that something funders should get on board with? Or what do you think the consequences of that would be for the industry?
Sure. So, I mean, the analogy that gets used all the time is insurance, right? It is very common because there is no other person that would be responsible for looking at these or making sure that ethics are being complied with or whatever. The easiest thing to do, and fine, black out the financial terms if you want to, but would be under the protections of litigation to turn over in the adversarial system, to turn over the LFAs and the identity of the funders, sort of at a minimum. That's what I've advocated for in the past. That is exactly what the insurance industry does. It's never gone further than that. And there are already discovery disputes about these things. There's already far-ranging implications on standing and other things that have come up. I think that would at least give us an accurate picture of how many cases are funded and which cases are funded. It would make investors feel a little bit better because they would know that there's no cloud over their cases where it could be discovered, something might happen. And it would also limit the extent of it, because once, I've heard funders say this again and again, once decision makers and the other side see these LFAs and see that they are what they say they are and that these are arm's length funders, it's going to become a non-issue, right? And I think at that point, judges will start to say, yeah, it's in the record. I see it. I know my conflicts. There's no issue moving forward. And I'm now not worried about the boogeyman of what I don't know, right? I think that would also give any other governmental agency sort of the comfort that there's not some crazy story or boogeyman happening behind scenes where the Chinese government is funding something or something else is happening that they don't know about. Like, there's nothing that the military or that the government hates more than the idea of having no way to know what's happening behind closed doors, right? If they have a sense that everything is being disclosed, or at least everything is supposed to be disclosed, I think that it becomes a non-issue, and then it just turns into another facet of the industry and another facet of practice. So that's where
What about the argument that some funders might make that you give an inch, they take a foot, that this is sort of opening the door, cracking the door open for regulation on an industry where a lot of funders make the case that this, that there doesn't need to be that, like, disclosure. If they give up on disclosure, that's not something that they should have to give up on. So then it sort of opens the door to other forms of regulation coming in.
Yeah, and I just don't think that's reasonable, because what normally ends up happening is that some political development that you can't predict happens, and then you get maybe not regulation, but a ban or something that is far worse based on some horror story or something that came out after the fact. So if you engage constructively and you kind of work with parties to come up, which is exactly what's happening in the converse in the UK under PACAR, right? They're all coming to the table because they have to. They're all discussing what reasonable light touch regulation looks like. They're all talking about disclosure. Same thing happens in arbitration bodies internationally. Same thing happens in the Dubai financial markets, right? Once you get past this idea that you don't have to, and why should I have to tell people, or I don't have to right now, I think you get to a point where you're constructively engaging on something that turns it into a non-issue. And then if there's another wave of people trying to regulate it, at that point, the industry is already out in the open. It's happening. It's recognized that it's 20 to 40% of all litigation, and so nothing's gonna change. The other piece of this is that funders don't know what other funders are doing. So one funder, especially one that's publicly traded or has a lot of scrutiny on it already, or has large LPs that are sophisticated, might be doing everything completely the way they're supposed to. But they probably live in fear of some other unknown person trying to copy what they're doing, sort of like dumb money following smart money, and doing it very poorly and creating a fact pattern for a case that goes up to the Supreme Court, or that goes in front of somebody that does what PACAR did and just helps to bring down the whole industry based on some bad fact pattern or whatever, right? And I think you can avoid that if you're seen as constructively engaging, if things pass, if they move forward, and everybody feels like it's moving in the right direction. To just resist and say no almost always eventually means that there's a breaking point where things go far further than that point. And I just think that's what's happening here.
So let's say we get to a place of disclosure in the industry. Sure. That's becoming the norm. How would you recommend that funders and stakeholders, let's take IP patent claim holders, how should they prepare for that?
Well, so there are a couple of industry groups, not many, that purport to come out with what they think are, or at least internally they probably have, sort of model contracts. Every contract is going to be a little bit different, and every LFA is going to be a little bit different. But if the industry can prepare to self-regulate, right? So if like the big players like Burford and Fortress and others can come together and say, look, this is what we think an arm's length relationship looks like. These are the contractual terms that don't confer control. These are the terms that we want blacked out. And this is sort of our best practices. And they share that amongst the industry, even if others differentiate or deviate, get in trouble for it or whatever. They can step in front of any calls for regulation and say, look, we've already self-regulated. We've already put together what we think is a model contract that if you tell us to change it, we will, but this is basically accepted. This has the gold stamp. This is the industry standard. It's something similar happens in antitrust with review letters for patent pools, right? Where patent pools will go ahead of time to the DOJ to try to get a letter of assurance that their structure does not run afoul of antitrust laws. If you know that you are meeting an industry standard, even if that is a self-imposed, hopefully public industry standard that's shared with regulators, it takes a lot of risk out of the contracts, because what this is all about is like, this is a very risky area, right? These investments are highly volatile, and some people stand and make a bunch of money according to their internal documents, and others are losing their shirt, right? And so LPs and investors would feel a lot more confident investing in this area, and probably end up being more successful if they could reduce the risk of that by just having sort of a standard playbook for an arm's length transaction. That doesn't prevent people from doing other types of transactions and making things different. And I know there's a fear of commoditization by sort of sharing with people how you write these things or whatever, but I think we're well beyond that at this point. I think there's more than enough players in the industry that have that information, that I think it would be helpful to have kind of a best practices or model contracts, if you will.
Yeah, I mean, I think things definitely seem to be headed in that direction. There's definitely, like you mentioned, the bad actor thing, and I know PACAR's scared a lot of folks in the industry, and also just this talk of, like members of Congress talking about foreign entities potentially funding, which what if that first came out, I remember people in the industry is sort of eye rolling at that, but now here we are, like it's been a year or two since that talking point first emerged, and now it's like for real.
Yeah, on that,
putting it out.
I think the story of regulation in this space is kind of one of you don't know what you don't know, right? And so people say, oh, parade of horribles, there could be all these things that happen, and the other side goes, that never happened. And it's like, okay, if you're Burford, you know it's never happened in your contracts, you know it's never happened in your deals, but you have no insight into your competitors and no insight into what other bad actors are doing. So then one example comes out, right? It's like, oh, there is a foreign funder, right? Well, that's just one example. That's not the right one. And then it turns out that another competitor is from a different foreign country. And then you're like, well, that does happen. There'd never be a conflict of interest where the firm is owned by the same people. And then that happens in like one bad example. It's not necessarily endemic. It's not necessarily something that is typical of the industry, but it starts to become sort of a brick after brick, like a lot of ammunition for the other side to pass far more severe regulations, right? And far more sort of opprobrium over the whole industry. And so I don't know. I think it would be better to get ahead of that. But again, it's always harder to get. Industries are non-monolithic, and they're certainly not playing with each other. They're competing with each other as well. So it's always harder to get people to come together to do something that's forward-thinking than it is to do something that's reactionary. It's far easier to react and say no, and put your head in the sand, and wait for a PACCAR crisis. I just think people need to be prepared for the other side of that, which is if that happens, let's say there's a tax court somewhere that decides that the tax treatment of these things was wrong and it was wrongly decided. I don't know enough about tax. I'm not a tax person. Let's just say that happened. And then suddenly next year, the industry is going to Congress and demanding some kind of fix. I'm not sure they're going to be met with receptive voices after they've resisted for so long other aspects of regulation, right? Maybe they will, maybe it won't matter, but I think they just run the risk of being on the other side of the issue, like they are in the UK, and it falling on deaf ears.
Yeah, well, Jonathan, I appreciate all your thought leadership on this. You've definitely been very active and upfront on it. I highly recommend folks if they're interested, follow you on LinkedIn. There's a lot of content there that you put out, and then of course visit you at the website unifiedpatents.com to find out more information about what you guys do. Really appreciate you coming on here and sharing your thoughts with us.
Yep, happy to be here, and thanks for having me.
Thank you. We hope you enjoyed this, and we'll see you on the next episode of the Legal Funding Journal podcast.